Yes, Mr. Braley.
I don't want to eat up too much of Mr. Moulin's time, so a quick 5 minutes. Just on the abuse point, could I first of all go to page 2668, which is the judgment of the Mauritian Supreme Court in 2000 when it got remitted back. And the reason I wanted just to refer to this is because after the Judicial Committee had ruled before, it got remitted back to the Supreme Court as to what to do with the judicial review. And the Supreme Court essentially dismissed it because of the civil claim.
Because?
Of the civil claim.
Yes.
And so it's a very short judgment, 2668, following the decision of the Judicial Committee or the Privy Council, etc., allowing the applicant's appeal, granting it leave to apply for judicial review, the applicant is seeking a declaration, and then you get the relief. And it is a very short judgment. What then the court says is, learned counsel for the respondent and the co-respondents have taken a preliminary objection, and in view of the fact that the applicant has a civil claim against all their clients on substantially the same matters mentioned in the application, the applicant should elect to pursue either its application or the civil claim, but not both. It goes, it is an uncontested fact the practice of this court has always been to maintain at all costs procedural divide between public and private. And then it goes on, in the course of the hearing, we highlighted that fact to counsel. And then it goes on, after the ABC, we owe it to learned counsel for the applicant, I believe that was Mr. Moulin, that certain matters can be determined in the civil proceedings. And then the court says this: we have declined to exercise our discretion in favour of the applicant for the following reasons. Paragraph 1, which is paragraph 2, which is inextricably connected with paragraph 4, which is going to be thrashed out in the civil claim. Consequently, we cannot prejudge those issues which in any case form the basis of the civil claim, but prefer to leave them for determination at the trial. The more so, as the Judicial Committee of the Privy Council has explained, the purport of certain provisions of the Act, but left open the question of whether or not the respondent and the second co-respondent had fulfilled their obligations under the Act. So there is a recognition here that the question is, what is going to be determined is not whether a duty existed, but whether they had fulfilled their duty. With regard to paragraph 1 above, which concerns the declaration, the Supreme Court says a declaration will serve no useful purpose in the circumstances given it is apparent from the judgment of the Privy Council that under the Act, the respondent and the second co-respondent were empowered to protect the applicant from unfair competition, as conceded by counsel for the respondent and the co-respondent. So the co-respondents on the remittal back expressly conceded that the Privy Council had essentially imposed the conditions to protect Emtel. And then, however, the issue as to whether there has been in fact cross-subsidisation of CellPlus by MT cannot be prejudged, but must be determined at the trial. The more so it forms part of paragraph 2.2 above. Now, I mention that because it is quite clear that after the judgment of the Privy Council, it went back. Emtel was still seeking judicial review to force the authority to ensure the conditions were complied with. And the Supreme Court said, no, we're not going to make the declaration, we're not going to force anything. We're going to leave Emtel to the civil claim. But the important point is that essentially MT and CellPlus at that time, in 2000, were saying the real issue now is whether there has been cross-subsidisation. There was not a hint of a rehashed argument that we face now that there was no vires to put it in, there's no vires to have it in a separate document. You need all these conditions in one single document. So the judicial review claim was dismissed essentially on the basis of certain representations made by counsel for the respondents that the core issue was whether, in fact, cross-subsidisation existed. And we get that from the last sentence. Counsel, so empowered to protect the applicant from unfair competition as conceded by learned counsel for the respondent and the co-writ. The issue as to whether there has in fact cross-subsidisation of third co-respondent, that's Cell Plus by MT, cannot be prejudged but must be determined at trial. And that is why MT's defence and Cell Plus's defence accept that the conditions were imposed on them. They recognise that in the light of the Privy Council.
Had those defences been served by the time this judgment was?
2007, was it? The answer is no, my lady. The
Judgment's 2002.
2007. So the defences came
Sometime after.
sometime after, yes.
Yes, they would have done.
Yeah. I think there had been some requests for particulars,
I see.
which were very, very lengthy. Some of the particulars, as we said in our written case, related to paragraph 11.1, but there were lengthy particulars sort of the statement of claim. But the important point is that the defence is consistent with the concession at the remittal hearing, in the light of the previous committee's judgment, that really the key issue was cross-subsidisation, not a hint of any argument about a single document theory, that these conditions, which they knew were contained in the correspondence, that these conditions had to be in a single document. And that is why, in our grounds of appeal, I won't take up time, but at 3072 and 3082, we say that this single document theory should have been raised in 2000. It is contrary, we say, to the way that the respondents conceded the case on the remittal in order to get the judicial review proceedings swept aside, contrary to the pleaded case, and on standard Henderson and Henderson principles, it is an abuse that this single document theory should have been raised before, and it is contrary to the pleaded case as it stood for the best part of 16 years. And we will, if necessary, rely on the established case law that it is an inherent power of any court to determine whether there's been an abuse. And so with that submission, if I may finish, unless there are any questions, I'll pass to Mr. Moulan.
Yes. Thank you, Mr. Braley.
Thank you. I'm obliged. Thank you.
My lords, my ladies, earlier this morning, Mr. Braley has set out the factual background of the appeal. The appeal, as far as the ICJ is concerned, relates to the regulatory inaction of the authority, which caused harm to Emtel, and which inaction gave Mauritius Telecom and Cell Plus free rein to compete unfairly with Emtel. Emtel was pleading for protection, a plea requiring protection on a level playing field, and that plea for protection fell on deaf ears. Now, Emtel is appealing the Court of Civil Appeals judgment in the appeal against the ICTA. That is the 2021 judgment at page 2790. I also propose to refer to a 4-page judgment of the Court of Appeal of 30th December 2013 at page 2687 in due course. 2687. Thank you. This appeal, we say, is the appeal against the ICTA judgment. I say the judgment is wrong for 3 main reasons. Firstly, the Court of Appeal should not have allowed the ICTA, the new authority, to re-argue or revisit what had been conclusively determined by the 2013 Court of Appeal as to the scope of the transitional provisions. The Court of Appeal was also wrong because the point was expressly dropped and not developed by the ICTA's counsel in 2009 before the trial judge. That will be at page 392. I'll refer to it in due course. Further, having regard to the evolving nature of the plenary objection of the ICTA, the Court of Appeal was wrong in allowing the ICTA to articulate that it could not be held liable because the TA was not a legal person. Second, we say the Court of Appeal fell into error when it disregarded the correct construction of the transitional provisions. Instead, it embarked on an issue of liability flowing through those provisions. Third, the Court of Appeal erred when it held that the TA could not be sued in its name because it lacked legal personality. We say this point is academic once the construction of the transitional provisions is correctly made. I'll try to give some context first before addressing the ICTA's objections and how they evolved over time to eventually take the form you will see at the close of the pleadings. You'll remember that the point is not raised before the last day of trial on 17th of June 2016. That is the first time that the nature of this point will appear, and not even as it is now being put forward to you. Then I'll address the construction of the transitional provisions. My lords, my ladies, the context shows that history is repeating itself. In 1996, the Telecom Authority advanced a very narrow construction of the 1988 Act, and today it advances a very narrow construction of the transitional provisions. It did so to shield itself from judicial review proceedings, and it perpetrated that narrow construction aided by CELPLUS. What is important is to read, and I'm not going to do so, but if your lordships and ladyship could do so in due course, at page 5921, the TA asserted that the 88 Act conferred no power or duty on the authority to regulate competition. And CELPLUS just then went on to say, at page 5922, the regulation of the competition was not within the purpose of the 1988 Act, and accordingly the authority had no power to impose any condition providing for the appointment of an independent auditor or for preventing cross-subsidization, and such conditions were accordingly ultra-virus and unreasonable. I say so to show that this position, this narrow interpretation, will repeat itself now again. Lord Bingham decided that this was not correct and stated in clear language, it cannot be thought that the TA had power to license such competitors, but not to control the terms on which they were to compete. The highest court of the land explained unambiguously that the Telecom Authority had the power to regulate and discipline both MT and CELPLUS, and that MT was not immune for the regulatory regime of the 88 Act. The TA did impose conditions, Mr. Bree has come to that extensively this morning, but it failed to enforce them. That is the basis of the claim. My lords, what is a tort under French law or Mauritian law? It is an act which must be a foot. A foot is a characterization of an act. The act happens, the law will decide, and the court will decide whether it is negligent, reckless, or intentional. The next step is whether this has caused damage, well, whether there is damage first. And this last step is whether there's a causal link. It's a very simple way under French law to apply Article 1382, we say, and I'll come to that a little bit later. What we say is that the regulatory inaction of the Telecom Authority harmed Emtel and is the basis of the claim in tort against the successor-in-law of the Telecom Authority, the ICTA. By 2000, the harm had been done. I'd like you to keep in mind 3 dates. Firstly, 15th of January 2000. That is the date where the Telecommunication Act 1998 comes into force. The Telecommunication Authority, the TA, for the 88 Act disappears and is replaced by the Mauritius Telecommunications Authority, MTA. And the second date is that at which the MTA disappears, which is 15th of July 2002. Sorry, 1st of July 2002, my apologies.
Right. Which year?
1st of July 2002. So The MTA will exist between the 15th of January 2000 to the 1st of July 2002 for a period of 1.5 years. It is important to say this because you will see time and again the argument being put forward of dead persons having sued a non-existent entity. Now, whether or not the Telecom Authority existed is of no consequence. The MTA existed on 2nd of July 2000 when the civil proceedings were issued. That is the important part. It is not a non-existent entity which was being sued, it was a person in existence.
The MTA?
The MTA, my lady.
Yes.
No proceedings in the civil claim were ever issued against the TA. It had disappeared on 15th of January. So by June 2000, Emtel had incurred substantial losses and needed to be compensated for the anti-competitive behavior of Cell plus MT and the inaction of the TA. By 2000, when Lord Bingham gave judgment, it was too late for the TA to undo the harm done. The harm having been caused, when I said 15th of January 2000, I forgot to give you the reference. It is at page 3417, a proclamation of 2000, which brought the 1998 Act into force.
What was that page number again?
3417. 23 years later, my lords, my ladies, we are before you again, anew, and yet faced with an argument that perpetuates a narrow construction of the transitional provisions. We say an untenable transition. And the 88 Act, which is yet again to shield the ICTA from liability for its tortious action. And I'm very clear, it is the tortious action of the ICTA for which is being sued, not somebody else. The deeming provisions do exactly that. I'll come to it in a minute. Over the course of 16 years of litigation, the ICTA drip-fed its objections. It was as if the ICTA was playing, and with the highest respect, a game of catch me if you can. What is today being characterized as a fundamental defect in Emtel's case was a point that was never pleaded and never raised by the ICTA for the better part of 16 years of litigation. And for that reason, I would ask you to come to the pleading. So we've already seen it with Mr. Brealey, but it is useful to see the case against the ICTA. If one were to turn at page 8 and 9, paragraphs 1, 1, and 2 are admitted by the defendant number 1, the ICTA. We'll come to that in a minute. But what does it say? Prior to 1988, the whole of the Telecommunications Act in Mauritius was run, insofar as overseas telecommunications was concerned, by Cable and Wireless, and for inland through the Department of Telecommunications. In about 1984, government formed a wholly owned subsidiary, OTS. On 1st of January, OTS, by private and common agreement with Cable and Wireless, took over the assets of Cable and Wireless in Mauritius. And in 1988, the government founded another wholly owned company under the denomination of Mauritius Telecommunications Services Limited. It will become MT in due course, to which the undertaking of the department was transferred by the Telecommunication Transfer Act 1988. And the 11 provisions are set out. We'll come to that in due course. However, may I simply sit here for a minute to ask you to read paragraph 3.2. For the purpose of this section, but subject to subsection 3, the undertaking of the department shall be deemed to consider, paragraph 1. Notwithstanding subsection 4 or any other enactment, the undertaking of the government relating to the department shall in the appointed day vest in the licensee.
So I'm sorry, you've lost me. Where are you?
Page 9.
Yes.
Paragraph 3.
Yes.
Of the Act, Telecommunications Transfer Act.
This is setting out Section 3 of the Transfer Act 1988.
Yes.
So the undertaking of the government relating to the department vested into Mauritius Telecom. That is important. And it was such, it says that for this section was subject to subsection 3, the undertaking of the department shall be deemed to consist of such assets, whether movable or immovable, as may be agreed upon the department and the licensee, MT, and the rights and liabilities of the department other than the rights and liabilities which are vested in the Telecommunication Authority. That is important to consider, that in 88, government intended the TA to be the recipients of rights and liabilities. It has an important bearing, we say, on the question that we are going to examine later. We then go on to say that the staff of...
So the effect is that the government was doing all this, the department was doing all this, and then in 1988, the role of regulator and the role of telecoms operator was split, and the rights and liabilities of the department that belonged to the operator were then transferred to Mauritius Telecom, and the rights and liabilities of the regulatory part, the regulating part, were transferred to the authority.
That is exactly what's happened, my lady, and I agree with that. It has not been stated in so many words by the respondents that this is that they agree with that part, but as you will see, they have the authority admitted that paragraph 2, which is why I wanted to set it out first. In their pleadings, they will say, yes, this is correct.
So the effect of that would be that if somebody had a cause of action against the department for something it had done before this, they would have to sue either the authority or Mauritius Telecom, depending on which part of the department had done whatever it was and whether that was best characterized as an operator type.
This is the conclusion we come to as well, my lady. And we say the whole point of coming to say that the authority had no legal personality by reference to words only, it shall be a corporate body, are incorrect to understand the true purport. But
that's a separate point. At the moment, I'm just thinking about the shifting of the liabilities from the government to these two separate...
Yes, my lady, I agree.
To use a neutral.
Yes, my lady, we agree with that. Any cause of action which had arisen earlier were against one of the two, but not against the department anymore. At paragraph 3, we set out the transitional provisions in so many words, and section 51.1 and section 29.1. Now that is the case we put forward from day one. Every act done by or in relation to the Mauritius Telecommunication Authority established under Section 4 of the Telecommunications Act 1998 shall be deemed to have been done or commenced, as the case may be, by or in relation to the authority. And we say that the ICTA was liable, but the acts travelled then to the TA by reason of the fact that Section 29.1 of the 898 Act provided every act done by or in relation to the Telecommunication Authority established in Section 4 of the Telecommunication Act 1988 shall be deemed to have been done or commenced, as the case may be, by or in relation to the authority. We then go on to set out that the authority was the same for the 88 Act, the 98 Act, and the 2001 Act. And those functions included to issue licenses, was required to approve tariffs, and was bound to comply with the directions of the minister. Now, this is the case we put forward as regards the ICTA. If you were to turn then to page 17, at paragraphs 15.2, 15.3, 15.4, 16, 17.1, and 18A, what is said to be tolerance of the acts and doings of Mauritius Telecom and CellPlus are set out in full. Firstly, modifying the direction, failing and neglecting to exercise its statutory powers to regulate the license, failing and neglecting to protect Emtel from unfair competition, that such was a bias towards MT and the tolerance of the tortious acts of MT and CellPlus. And we say all this amounted to a fault, and that those have been committed in concert with or with tolerance of the authority. So the case is very clear. And when one moves to the particulars, I would wish at page 23, first to go to the heading. In the heading, you will see that Emtel is suing the Mauritius Telecommunications Authority, not the TA, clearly, and they know who we are suing. So there's no action against the TA ever started. And when you turn to page 29, questions 16 and 17, 18, the particulars of the case are set out very clearly. At page 40, question 19, will the plaintiff give particulars of the bias of the fault? And is again set out clearly. Refraining or refusing to monitor the condition of the license, illegally modifying the license, permissiveness of the TA allowed CellPlus to unfairly compete with Emtel, and MT to abuse its dominant position. And this goes on. There is no hint that they do not understand what case they have to meet. We say it clearly. The transitional provisions make the acts of the TA those of the MTA and those of the ICTA, and therefore you're liable because the TA did not act. This is the case that is being put forward. There is a clear recognition in the written closing at trial of that state of affairs. If you were to turn to page 1556, paragraph 57, on the assumption denied by the defendant number 1 under the above paragraphs, the 1988 authority is a proper party to these proceedings. Remembering the 88 authority was never sued, so this was a wrong premise. The following position results. 1, any acts done by the 1988 authority were assimilated to the 1998 authority by section 29, and thereafter assigned to the 2001 authority by section 51. So this is accepted. Now this is the case.
Sorry, this is ICTA's.
I apologize.
Sorry, this is ICTA's
Closing submission of 17th of June 2016.
It says on the assumption denied by defendant number 1.
Yes, that the 1988 Act was a proper party to these proceedings. Now, the 88 authority was never a party to the proceedings, my lady.
Oh, the 1988 authorities.
Only the 98 authority was the one which was being sued. The 88 authority was never a party. There we say is the mistake. Now, the iteration of the authority's primary objection is to be found at page 349. It says, in quite a cryptic manner, the following. Defendant number 1, in limine litis. Defendant number 1 moves to be put out of cause inasmuch as defendant number 1 cannot be held liable in law in respect of facts disclosed ex facie the administrative claim. Now, in 2009, when counsel for the ICTA will offer submissions on this plea in limine, we'll find that to page 388, line 17. And the trial judge said this at page 392. She had to seek clarifications, and she said...
I'm so sorry, can you give me the reference
Page
again?
392, line 15. The trial judge says, it is almost very useful that whenever a defendant avers that there is no cause of action, that some sort of details be given that to be able to enable all parties in the court to follow, because as it is now, I'm still waiting for your arguments. And the concession from counsel, he says, yes, I have to concede that the court is not aware of the exact nature of the plea in limine. Now, at page 388, lines 26 and 27, is the point I want to come to. The ICTA alludes to the fact that the 1988 authority is not a body corporate, but it does not make the point which is advanced today, that the proceedings are a nullity. And this will be found at page 392 again, line 5. It's a bit complicated to follow. The court says the following: Mr. Uzier, understand your plea in limine to be based on this particular point, that the two regulatory bodies which were set up under the most recent legislations had a corporate entity, whereas under the first legislation, the 1998 one, it should be 88 one, the authority didn't have any corporate entity. Yes, this is the first thing of your argument. And so what is it afterwards, you know what I mean? Mr. Uzier replies, no. Of course, it's what must be tied to, my lady, this was not my first name about. Then we move on a little bit later.
I'm sorry, which page was that?
392, line 5 onwards.
I thought his point here was the distinction between acts and omissions.
Exactly.
Right.
That's exactly what he says.
Yeah.
So it was just to say that the point which is advanced, that when the court questions Mr. Uzier, that is it about the fact you don't have a corporate entity, he says, no, this was not my first limb. And that's the important part. On the first time this is ever considered, and this is on 3rd of March 2009, the judge asks, is it that you have no corporate entity? He says no. Then he went on to say that the authority cannot be held liable for any omission, and then he goes on to say that a little bit later. So the plea in limine, which was cryptic, is now explicited in being, well, you can be liable for positive acts, but not for omissions. And the fact it doesn't have a corporate entity is of no consequence. That is the case we have to meet in 2009. Now, the ICA chose not to advance the absence of legal personality in 2009, and it knew about this point, and it chose rightly, we say, not to advance it. The ICTA's counsel limited his point to the contention that it could not be liable for omissions. The ICTA was not troubled by the lack of legal personality of the TA point. And you will see that also on appeal in January 2013, page 588. Line 7, sorry. In fact, what we are submitting, given the nature of the authority upon which the transition took place between the 1988 and the 1998 Act, it could only mean a positive act, as should be construed in the natural ordinary sense, act done, act commenced. This is what it states in that particular section. It is not just an act, an unlawful act. The legislator has taken the pain to qualify. It is an act done, it is an act commenced. It can only mean positive and not the failure to carry out certain things. My Lord, this will be my submissions in relation to the ICTA. So not only is it said in 2009, on appeal in 2013, this is repeated. And that's the important part. There is no hint of what's being said today that this would be taken at the closing. We say, my lords, my ladies, that Mr. Uzier for the ICTA and the late Mr. Badab for the ICTA again in 2013 can only be making an informed, voluntary, and unequivocal election not to rely on that objection that the ICTA may not be held liable for the acts of the TA because it was not a corporate body. And in the words in Lord Bingham, in Miller and Dixon, that is a clear waiver of the objection which the ICTA would raise 7 years later at trial.
Sorry, which was the reference that you referred to?
It was
Lord Bingham in
Miller and Dixon, my lord.
Miller and Dixon, thank you.
It is at page 4198 to 4200, my lord. Now, the 2011 judgment was appealed and lost. It is not gainsaid that this judgment of 2011 has l'autorité de la chose jugée. It cannot be otherwise. There will be no less than 3 interlocutory appeals, all of them taking a few years to be solved. If they chose that path, then they must stay with the fruits of their labor. The second iteration of the defense emerged on the eve of trial in a letter from counsel to the court. At a pretrial case management conference on 22nd of April 2016, counsel for the ICTA stated he would file a defense with 4 pleas in limine. The trial judge was extremely unhappy, and you can read her unhappiness and displeasure at pages 753 and 754. I will not go through it. But the 4 pleas in limine are as follows. Firstly, a breach of the fair trial within reasonable time constitutional guarantee, time bar because the Public Officers Protection Act had not been followed for the 2 years limitation period, barred because there was no statutory notice of 1 month, and the evidence of Emtel was inadmissible under the Public Officers Protection Act. Again, there is no hint of argument that the ICTA cannot be sued because the TA allegedly has no legal personality. And when you will look at the amended plea which is put forward, and I invite you to read in due course at page 5245, again, no one could see that what is meant is, at the end of the day, well, you know, liability could not travel, which is not what we say. We say the acts travel. We didn't speak of liability. In a ruling of 29th of April 2016, the trial judge dismissed the plea in limine and said it was not open to the ICTA to re-argue the POPA point and that the plea in relation to due process was premature. And these are matters stood until close of pleadings in close of submissions in trial on 17th of June. And the third iteration is on the last day of trial, 16 years after we initiated the civil proceedings. For the very first time, counsel for the ICTA argues that the TA was not endowed with legal personality. And at page 138498, it says, the proceedings ab initio were therefore entered against a non-existent entity. And that is the mistake. They were never entered against the TA. They were entered against the MTA. The same submission made is ICTA's written closing at page 1550. And we say, my lords, my ladies, this is where the ICTA abuses the process of the court. The raising of the defense late in the proceedings amounts to abuse if the court is satisfied, the onus being on us, that the defense should have been raised earlier in the proceedings, if it was to be raised at all. When one considers the manner in which the ICTA conducted itself, by first accepting that it would be liable for the positive acts of the TA, but not its omissions, irrespective of the TA status, and then by seeking 7 years later to argue that the status of the TA meant the ICTA could not be held liable at all, my lords, my ladies, this is clearly abusive. The trial judge did not need to find the ICTA's conduct abusive because she rejects the ICTA's line of submission in the first instance judgment at paragraph 280 of the judgment, which is page 2673. Because of time, I will not go through it, my lady, my lords. The point that the acts and omission of the TA passed to the MTA and the ICTA was decided in the 2011 judgment of the trial judge, and she held the function at page 2675, 2676. The function of the successive regulatory bodies was set down in the statute as a number of positive acts to be carried out. True, it is important that acts and decisions of the defunct regulatory body be recognized and taken over by its successor. However, to say that if the defunct regulatory body has failed in its duties and has been guilty of an omission, its successor is not liable for the failure or omission is to give too restrictive interpretation of the transitional provisions and runs contrary to the raison d'etre of the provisions, which is to ensure the continuity of action of the successive regulatory bodies. That way of continuity of action will be accepted in due course.
This is her judgment on the original in limine.
Yes, my lady. And the judgment was affirmed of appeal, and therefore, which we say, has l'autorité de la chose jugée. We respectfully submit that this approach was correct. It gives effect to the intention of Parliament to deem the acts of the TA and omissions to have been done by the ICTA. We respectfully say that the effect must be given to the finality of these decisions.
So do you say that, suppose that the MTA and the ICTA had never come into existence and it had been the Telecoms Authority all along, or suppose you had sued them before 1998 and you'd sued the...
My lady, one of two persons would have been...
Finish my question.
My apologies.
You'd sued the Telecoms Authority. Then they may have raised the point that you've sued the wrong person because the Telecoms Authority is just a branch of government and you should sue the government. And then the government would have said, you can't sue us because we have an immunity in Section 29 of the 1988 Act. But your case, as I understand it, is that even if that is what would have happened, because the MTA is undoubtedly a legal person, and because under the transitional provisions the acts of the part of the department that became the Telecoms Authority are attributed to it, then you can jump over that problem of whether it was the Telecoms Authority or the government before 1998 and sue the MTA and then the ICTA. Is that...
I respectfully agree, my lady, and this is exactly why this issue needed no determination. There was no need to determine whether or not the Telecom Authority had legal personality because Section 29.1 and Section 51.1 do not require any such determination.
So even if the liability had lain with the government rather than the Telecoms Authority before the MTA came into existence, it now lies with the MTA.
Yes, my lady, but it could not have lain with government. The TA, my lady, is a statutory body. It acted. It had to issue licenses, to modify those licenses, it could revoke those licenses. It had the duty to protect them.
Yes, I understand that point, but I'm just looking at trying to understand what your case is on how the transitional provisions.
If I may put it, my lady, it's a bridge between the acts of the TA and the acts of the MTA, a deeming provision. And that deeming provision then occurs a second time with Section 51.1. It is those actions that are transmitted. The legal qualification of those actions happens later at trial. There is no need to go any further. It was my first submission to your ladyship. And when the ICT argues in paragraph 57.2 of its written case at page 3045 that the issue was not litigated or decided, well, it is incorrect because Emtel had initiated proceedings against the MTA and amended it to replace it with the ICTA. And the only context in which the issue could have arisen was in relation to the ICTA's liability and whether the ICTA could be liable for the acts and omissions of the TA pursuant to the transitional provisions. That issue was decided in 2011 and closed. I've already dealt partly with the correct interpretation of the transitional provisions, and I'll try to go over it quickly.
Not too quickly. I'm struggling a little to hear what you're saying. I know it's my fault.
I'll try to speak quicker, but I do realize I've got 15 minutes, and I'll try to speak a little bit.
You can, if you need to, always go on beyond 15 minutes, but it will come out of your time at the end of a hearing.
Certainly, my lord. Thank you.
But if you could keep your voice up, some of us aren't as young as we were, and even at this distance, I'm straining to hear you.
I'll try to speak a little bit more loudly. The Court of Appeal relied on Section 17.3c of the Interpretation General Clauses Act to hold at page 2804 that the right of Emtel in continuing any proceedings in respect of any act done by or in relation to the TA is preserved and held if there was no liability which could accrue to the TA by reason of its lack of personality, the risk remains unaffected by the repeal of the 88 Act and the enacting of the subsequent transitional provision. And we say this respectfully is incorrect. The correct way to look at the transitional provisions is that the ICTA and the MTA inherited the acts and omissions of the TA by operation of the transitional provisions. We need not look in the issue of legal personality or in the issue of liability. Liability is a legal construct based on whether the act is or is not fautif. And whether the act is fautif has been found beyond doubt by the learned judge.
But isn't there also an immunity conferred in the 1998 Act and the 2001 Act on the MTA and the ICTA?
Can you give me the section 22? Yes, my lady, there is. The immunity is for the acts of a licensee. Can you give it to me? Which page? Which page is it? 22. Just give me the page of where the act is. The 88 Act. I'm sorry, my lady. I found it. If you could turn to page 29. Page 3369, section 29. No liability shall attach to the government in respect of any action, claim or demand by any person in consequence of any damage arising from anything done or omitted to be done by a licensee. My lady, I would read that as part of Part 2. In Part 2, a licensee is given the right to enter, lend, and to do all kinds of things in order to establish a telecommunications service. And I would say that this is the immunity that government asked. And you will see that, in relation, to sections 15 and 16, which is the powers of a public operator and the obstruction caused by trees and hedges. Now, before you used to ask for a way leave and enter land to be able to put forward pose and so on. Now, if the infrastructure caused any damage, government would be therefore immune of liability. But when you read the Telecommunication Transfer Act, it cannot be otherwise that the TA would be liable for its own actions, not government. And this concerns, in my respectful submission, the power which is given to them when they do enter land and they do, at that point, cause damage to other parties.
What about the immunity conferred on the MTA in the 1998 Act?
Now, the immunity covered with the MTA is for its own actions. It's a different type of immunity, and it's not relevant to this. If you were to turn to section 3403, section 22, no liability, civil or criminal, shall attach to the authority or to any member or officer in respect of any loss or damage arising from the exercise in good faith by the authority or by a member or officer of his functions under this Act. Now, it's a different type of immunity, my lady. It is not for the acts of a licensee. It's for the acts of the board of the MTA or an employee, a préposé of the MTA. I read it differently. It is not an immunity given to government in respect of the acts of a licensee. It's an immunity given to the authority for the exercise in good faith of its functions. My lady would remember also if I may. My lady would remember also that a finding of faute lourde extinguishes any liability, any exclusion of liability. If we have to go down to French law, we could do that. I did not think that would be relevant. But a faute lourde would by itself be a faute inexcusable, an inexcusable fault, which therefore would take away the immunity in a private contract. There is dispute as to whether immunity given in certain sections to by acts of parliament would or would not be waived. There is still a number of discussions doctrinally about it. But that is one of the points, if ever it had been advanced, we would have been able to discuss, but it's never been advanced earlier. It's only for completeness that I'm saying so. At page 2766, the trial judge found, paragraph 291, that there was a faute lourde. To my mind, there is no doubt that in the context of which conditions 7A and 7B came into being put upon the TA a responsibility to ensure compliance with the conditions which it had itself set. Instead, the TA completely disregarded its responsibility, failed to administer the prescription plus ferme, and shown tolerance of the breach of the conditions. In these circumstances, it can only be concluded that it has committed a faute lourde.
And you say the effect of that is to knock out the immunity in Section 22 and the equivalent for the ICTA in the 2001 Act?
I would say for ICTA in 2001, it does not apply because it must be an act in good faith to which it applies. A faute lourde per se is in bad faith. As to the 88 Act, then yes, my lady, if ever the immunity section would apply, then the finding of faute lourde by itself would constitute a defense against an exclusion clause, including an immunity clause. We say that finding cannot now be contested on appeal. And as I've said earlier, where the Court of Appeal and the ICT get it wrong is when they argue that liability cannot pass through the transitional provisions because the TA was not a legal person and could not bear liabilities in tort. With respect, it is the wrong way to look at the scope and effect of the provisions. They do violence to the clear wording of the provisions. My Lord Briggs, in Fowler and Revenue Commissioner, Customs Commissioners, at page 3842, put forward 5 propositions in the context of deeming provisions. Respectfully, we say those 5 propositions are here fully complied with. I will not go on the propositions 1 to 4, which are all there. I will simply read the 5th one, which I believe is important. But the court should not shrink from applying the fiction created by the deeming provision to the consequences which would inevitably flow from the fiction being real. As Lord Asquith memory put it in East End Dwellings Company Limited and Finsbury Borough Council 1952 Appeal Cases 109 at page 133. The statute says that you must imagine a certain state of affairs. It does not say, having done so, you must cause or permit your imagination to boggle when it comes to the inevitable corollaries of that state of affairs. And we say this is exactly what the Court of Appeal in 2021 did. They focused on liability flowing through, which is not what the deeming provisions say. They simply say, imagine that the acts of the TA were or were not done by the MTA, and then imagine that the acts of the MTA were or were not done by the ICTA, and then let us come to the conclusion of what flows from that state of affairs. Trying to import the State Proceedings Act was irrelevant, we humbly submit.
So you rely on the difference in wording between the Section 22 and Section
22 again. 29, sorry.
As compared with that first provision which did vest liabilities and rights from the department.
Yes, my lady. As I've said earlier, the child judge or juge du fond found in favor of Emtel in the element of the three tortious elements in Mauritius. The point that we seek to put weight upon the transitional provisions, which it could not bear, and that the result put forward is absurd, does not take the ICTA very far. It would be rather extraordinary that when Emtel sued the MTA and the ICTA, no one would have been deemed to have done these acts. Somebody acted. It could have been either the authority, or let us say if it is not the authority, it was the state. The state where was represented by the Ministry of Telecommunications. Let's just take a very simple case. In 2000, in October 2000, a judgment for costs was made by this board. If it didn't attach to the TA, I agree maybe it couldn't attach. Well, certainly there was somebody who could bear those costs. It would have been the ministry. And that is the logical conclusion point that we're trying to make. The ministry was at all times present. Had we known of this point, then we could very well have amended our claim to say, well, in the alternative, if the TA is not liable, the ministry for whom it acted was liable. If it is not the statutory body, then it must be the Secretary of State at that point. Couldn't have been otherwise if it's not incorporated. They were both there. And what we say the abuse is to keep this until the end of trial on the last day when it was beyond repair on any of those cases. In the analysis, the question of legal personality of the TA does not assume any importance. It's a wholly irrelevant consideration. To sue or to be sued for a juristic person is a legal fiction. What that legal fiction does not do, or rather does not undo, is the acts of the TA, or rather here, the lack of action. There is another criticism at page 3048, paragraph 60 of the proceedings, saying, standing back, the position is this. Emtel commenced civil proceedings which were a nullity because they were commenced against a party which lacked legal personality. I will not go back into it to explain why this is incorrect. Again, at paragraphs 52 and 52.2, the IC argues, page 3040 and 3041, that Emtel is seeking to confer legal personality by reference to the transitional provisions. That is a mischaracterization of our case. It is no part of our case that liability is flowing through the provisions, rather that by operation of the provisions, they're a bridge to bring the acts of the TA to the MTA and thereafter to the ICTA. So at the end of the day, my point, my ladies, my lord, is that the question of legal personality of the TA is in fact a moot question. It should never be addressed at all. That is why the learned judge did not address it. You will see in paragraph, she does address all the points in her judgment, and more specifically, at paragraph 280, she says the following: whether ICTA should be liable for the acts of the TA during the claim period was considered in the interlocutory judgment handed down on 11 July 2011. The date is wrong, it was August. And I then ruled that pursuant to the transitional provisions under Section 29(1) of the 1988 Act and Section 51(1) of the 2001 Act, ICTA should be held liable for the tortious acts, if any, of the two regulatory bodies which it preceded. ICTA appealed without success. That's exactly what the judge says. She doesn't consider it any further. There is no need for her to consider the question of legal personality. But that being said, just for completeness, I will still address the question of legal personality, unless your lordships and ladies feel it is not necessary. As I said earlier, Parliament created a statutory body. That statutory body controlled a major sector of the Mauritian economy. Under Section 5, and I think it's all recognized, that body had very wide powers. I said the issue of licenses, imposing conditions, revoking licenses, approving tariffs. Now, if that statutory body fell into error, it is certain that it was open to a remedy in judicial review. I have no difficulty with that proposition. However, what I cannot understand is this. If it acted deliberately and breached its duties when it had created private rights, then it would be immune from liability, is what the ICTA is putting forward today. Now, that cannot be the case. As I say, it could either have been one of two persons, the Crown or the TA, but one of the two. And I say it can only have been the TA, because when you interpret the transitional provisions, when you interpret the Act, you looked at the 88 Act, not the surrounding 13 Acts, not the express words of being a corporate body or not. And the analysis of the Court of Appeal on that point is flawed. They come to say that the TA had no corporate body because it was not part of the statutory bodies, it couldn't act, its board was not proper. Now, I say all of these are improper consideration. It could have rights and liabilities. There is no other way to look at the Telecommunications Transfer Act. It did act all along, and everybody is sure about this. Now, in that case, if it could hold rights and liabilities, the question that it chose not to hold those rights and liabilities and to allow the government to pay or do whatever is necessary is neither here nor there. It could bear those rights and liabilities, it chose not to do so. That's a question of internal organization. It's not a question of it being a corporate body or not. It would be extraordinary that the authority would abuse its powers to assist under the licensee.
So are you saying then that the ordinary test which the Court of Appeal applied as to whether a public body has rights and liabilities doesn't apply here because that point is decided by the Transfer Act?
I apologize, but I didn't hear that.
Are you saying then that the Court of Appeal went wrong in applying the general law as to when a body has legal personality, because the question, can the TA be sued and sue, is answered by the Transfer Act rather than by the general law as to juridical persons?
I say that after the TA, after 2000, yes, my lady. But had it been done even prior to 2000, I say the TA would still have been held liable because it had all the trappings of corporate personality. It could hold rights, but it decided not to deal with those rights. And this is why Section 3.2 is so important of the Telecommunications Transfer Act. It could be subject to rights and liabilities, is my view, my lady. Now, Parliament could create a legal person with limited personality of what it was doing. It was obvious when you look at the context of the creation of the TA that government wanted to dissociate itself, and it does say so in express words, that this is in order to divest itself of all those responsibilities. The Prime Minister says so in his speech. I'll try and give you the reference in a minute. Now, if that is the case, and government tried to divest itself of those responsibilities, why would the TA not be able to hold those rights and liabilities itself? The fact that it had the points which are put forward by the Court of Appeal are simple at page 2085. First, it says there are 30...
What page?
2805. The first point is the words body corporate were not used, and says there are 13 acts which say so. So this is it. Secondly, it is not listed in the first schedule of the Statutory Bodies Pensions Act, Accounts and Audit Act. Thirdly, it was thirdly, it had no functioning board. Fourthly, it could not employ persons because it did not have financial administration powers as the other authorities had. Now, that doesn't take the Court of Appeal very far, because at the end of the day, that board was functional and acted. Cannot be said that somebody else acted. It was the TA. It's all recognized from the beginning to end. The TA did act. Now, the next part is, if it was not listed or it was not, the words were not used, that is what was necessary. What is necessary is that the words show clearly the intentions of Parliament to confer to it separate legal personality. And we say this is exactly what must have been done here. And more importantly, this is the way the TA acted on 2 occasions. At page 3586 and 3587, the TA made an application to the court because one Mr. Rogers imported an equipment which was a parabola to receive radio communications. And this is what the court says. An application has been made before me by the Controller of Customs and the Telecommunication Authority applicants for an order suspending the execution of the order made on 15th March 1994 by His Lordships V. Boulel, pending an appeal which applicants are about to lodge before the Supreme Court against that order. The order was to the effect that the Controller of Customs should deliver forthwith to Philip Rogers, the respondent, a parabolic antenna which the Controller of Customs, applicant number 1, was withholding on the ground that the applicant did not have the necessary permit. Those were not judicial review proceedings, they were plainly civil proceedings against Mr. Rogers. And there is no difficulty there for the TA to go to court. Now, how did it do so if it had no juristic personality? And evidence that it acted on its own is ascertainable again from another case, which is a case of, where's the London Satellite Systems case? The London Satellite Systems. It's the case of London Satellite Systems at page 3517. Sorry, I will ask you rather to go to the first case of London Satellite Systems at page 3496, where you will read the following at page 3498. At the last paragraph, on 18th March 1996, the préposé of the authority, préposé being the French word for the servants, with the help of the police, carried out a search on the premises of the plaintiff company at Queen Mary Avenue, Floreal, on the ground that the plaintiff company had, without the approval of the authority, installed radio transmitters at Floreal, was operating them on unauthorized radio frequencies, etc. So it did act independently with its own personnel to do certain things. Is it suggested that this was done by the state or by some other person or the minister? French law characterizes the 2 conditions of la réalité technique to give legal personality to a grouping, and that is an intérêt distinct des intérêts individuels of its members and an interest distinct of the individual interest of its members, and secondly, une organisation capable de dégager une volonté collective qui puisse représenter et défendre cet intérêt. An organization able to have a collective will which could represent and defend that interest. And I believe that in Mauritius, this has already been decided that on those 2 propositions and giving a purposive effect to the Act, and specifically Section 5, the logical conclusion would be that the TA had legal personality. It could be sued in its own name.
Mr. Whelan, you showed us Section 3 of the 1988 Transfer Act in your pleading. Do you have the bundle reference for the Act itself?
The Act, the Telecommunication Transfer Act?
Yes, the Section 3 of the
3378.
Yes.
Oh, thank you.
I'll get you immediately, my lord.
But,
It is at page 3377.
Yeah. So Section 32B,
Yes.
the Transfer Act is mostly about setting up Mauritius Telecom Ltd, the
Yes, my lord.
operator.
Yes, my lady.
And what Section 32B says that all the rights and liabilities of the department, other than the rights and liabilities which are vested in the Telecommunication Authority, vest in the operator.
Yes, my lady.
Where do we see that, or how are the rights and liabilities of the department which are vested in the Telecommunication Authority, where is that vesting provision?
We have not seen it, my lady. We have not seen any provision or any law passed after that that operated that vesting. What we do say is it was at least envisaged that the TA at creation, remembering all of those are passed at the same time, the Act of 1988 is Act number 10 of 1988, passed on 27th May. And the Telecommunication Transfer Act is Act number 11, passed on 27th of May. Both of them.
The most you can say, and it may be that this is enough, is that the Transfer Act, by excluding from the undertaking that's vested in the operator rights and liabilities of the department which it says are vested in the Telecoms Authority, it seems to be assuming that there is some vesting provision that splits those liabilities and leaves the department without any liabilities and splits them between those two bodies. But it doesn't actually exist as such.
We haven't seen it, my lady, as I say.
Well, it would be in the statute.
Well, yes, my lady, but there is, as I say, there is no statute that has been passed after that. So we do not know whether it's been done by way of internal transfer, whether it's been decided in a certain manner, whether it was just a generic provision. But what we do say is that it was possible that they inherit rights and liabilities because the Act expressly said so. That is what we can only say.
And then I think you say, if that's right, if the legislation vests the department's existing rights and liabilities in the authority, it would be very odd if the authority didn't then go on to accrue its own further rights and liabilities as it does its regulatory business.
Yes, my lady, this is exactly what we say.
And that then obviates the need to go into whether it's a
legal person,
corporation or a legal person, because the legislation vests it with the rights and liabilities.
Yes, my lady, it would.
And I think you refer to quite a lot of French authority in your case.
I have translated it, my lord, at page...
Indicating that there isn't the same categorization as we have in English law between natural persons and corporations established by statute. And I suppose there are also some anomalous legal persons which aren't in either of those categories. But for example, a partnership would be a legal person.
A partnership could be one of two persons, my lord. A partnership could be either an unincorporated partnership, then you have to sue every single partner. This is known as a société en participation. Or it could be properly made as a different legal person, and then it would be a société civile.
Yeah.
So your lordship is entirely right. The law qualifies it differently. But let me give you an example. Heirs, when they obtain their heirloom, they hold it en indivision, in undivided rights. Now, if you sue the indivision, the law has said all along, it doesn't exist. It's not a legal person. You must sue at least one of the heirs. So this is how it treats it. For a civilist, I'm a civilist, I'm sorry, I'm not very much of a public law person. But as a civilist, my lord, it is impossible for us to sue a non-existent person. I do realize that in England, a person which is not incorporated may be subject to judicial review. Asking me to say that this is normal under a civil procedure, I would say is anathema for me, but maybe I'm wrong on that. But this is the distinction I make between the two, and which is why I say, if this had been raised in any other manner earlier, at least we've been able to address the point, not on the close of pleadings. Lords, my ladies, I don't believe I can be of much more assistance unless you have any further questions.
Thank you very much, Mr. Mullen.
Thank you, Professor.
Yes, I thought we were going to hear Mr. Basset, but
Mr. Bassett's in Mauritius.
Ah, right.
And the intention always would be that I would speak on behalf of CELPLUS.
Very well. Thank you very much, Mr. Casey.
My lords, my ladies, in a moment, if I may, I'll make some preliminary remarks, which will hopefully help to anchor the point and the judgment of the Court of Appeal and of the judge in the relevant legal context in Article 1382. But before I do that, can I just clear up one specific point in relation to the Act? There was some discussion earlier on about MT's position and how MT could be made subject to a condition. If we can look again, please, at section 43.8, which is page 3375. The board will recall that the board back in 2000 also referred to this provision in the passage that Mr. Brealey relied upon. Now, in fact, the Mauritius Telecommunication Services Limited is the same entity as Mauritius Telecom. There was simply a change of name. That's recorded in paragraph 10 of the SFI. So in our submission, if one is looking at MT's position and whether one can get something from that about whether it must be the case that conditions can be imposed which are not contained in a license because MT is within the regulatory regime, the answer we submit was adverted to earlier by my lady, Lady Rose, that had the TA wanted to do so, it could have engaged the Section 12 procedure with MT, and it could have said, you're the holder of a deemed license. I take the view that it's going to be appropriate to impose a new condition on you. Here it is, and so on, then fulfilling the other requirements under Section 12.
Yeah, but I mean, it didn't proceed in that way. It imposed conditions on MT, which were conditions of the license granted to CELPLUS.
Well, my lord, we say precisely not. We say that what have been relied upon as conditions are not conditions of CELPLUS's license. And obviously I'll develop this in due course, but we say they can't be conditions of CELPLUS's license because the TA did not utilize one of the two pieces of machinery available to it under the Act to include those as conditions within CELPLUS license. It's correct that they were directed to MT rather than CELPLUS.
And I'm so sorry, but when you say didn't utilise the machinery under the Act, what are you referring to? Is this Section 12?
Section 11 first. So
this is a single document argument, is it?
Sorry, my lord?
This is a single document argument, is it?
That's a separate, that's a linked argument, but in my submission, yes. So Section 11 first, page 3360. We know that Section 5 provided that one of the functions of the authority is to issue, modify or revoke licenses under the Act. And then section 11.4 provides, we say significantly in mandatory language, every license shall specify, and then E, any terms, conditions or restrictions which the authority may think fit to impose. So we say, and we do submit this is not a surprising starting point, we submit that what's plainly contemplated is there will be a document which is conventionally recognisable as a licence, which will be issued, and that document, if conditions are to be imposed at the time of grant, that document must specify the conditions. Now, of course, as we say in our case,
forgive me. I mean, that does sound very similar to the one document point. You're saying it's different.
We accept in our case that a licence could well be drafted so as to say certain conditions have been expressed in another document and they're incorporated by reference.
So you accept it doesn't have to be one document?
Absolutely. And when we come to look at the licence in a moment, we'll see that by way of schedules and so on, it's arguable that this licence did that.
Yes, thank you. And you said there was a second mechanism that they didn't use.
Yes, and just before I leave section 11.4, though, just so that you have the context. There is another level to the point which I'll come to, which is that when you look at the licence itself, you cannot square with the language of the licence the idea that some part of it is to be found elsewhere. So the terminology of the licence itself excludes that possibility.
So the terms of the licence exclude incorporation by reference of any other document, you say?
Now, section 12 is the other piece of machinery, we say, which is available to the TA if it wishes to create licence conditions. And so we see at page 3361, the authority may, A, 12.1a, modify a licence if it considers that to be necessary in the interest of users of telecom services, etc. And then 2, where it wishes to modify or revoke a licence, it shall give notice to the licensee, A, stating that it proposes to do so, B, giving the reasons, C, specifying the time within which representations or objections may be made.
But this is a provision in relation to modification or revocation of a licence, whereas I understand the argument against you is that there was a licence which, from the outset, included the conditions.
Absolutely.
So if that's right, section 12 is irrelevant, isn't it?
Yes, although as we'll see when we see the judgment of the Court of Appeal, they did find section 12 of some significance.
Yeah, but that might be a criticism of the Court of Appeal. I'm just asking for your submission.
And I accept that it now appears that Emtel places no reliance on section 12. So if what have been referred to as the licence conditions have indeed become conditions of surplus licence, we submit it must have been by virtue of the TA exercising the powers it has under section 11.4.
Yes, thank you.
I think the relevance of the modification is that the removal of the auditor point and the substitution of, well, you can just give us reports and accounts, was a modification requested by MT and Cell Plus, and that was part and parcel of them treating that as if it had been a condition.
Well, my lady, again, we'll come to that. In fact, the documents tell a slightly different story and draw a distinction, if you like, between that dialogue and a separate dialogue which was going to, in a more technical sense, the contents of the licence. But just to return then to where I started, in terms of MT's position, we submit that it was entirely possible and would have been entirely conventional for the TA to say to MT, for example, we don't want you to cross-subsidise Cell Plus in some particular way. We don't want you to use the revenues of your fixed-line monopoly business to subsidise your new mobile subsidiary. And so we propose to introduce a condition into your deemed licence under the Act that you must not do so. And we say it's of some significance that it didn't do that, because for reasons I'll come to, it's clear that the TA was alive to the distinction between communicating things in the licence and communicating them outside the licence. But now, as I say, I'll come back to that. But by way of a following preliminary remark, as you've been told, Emtel's claims were brought under Article 1382 of the Code Civil, which is a general tort provision inherited from the French law from the Code Napoleon. And I think it's common ground that for liability to arise under Article 1382, a plaintiff has to prove, and we say plead and prove, foot or fault, causation and harm. Proving foot entails proving what would have been referred to in the judgments below as an act fautif. And if I can take you now, please, to some passages in Cell Plus's written submissions at trial, which are quite a convenient vehicle for looking at some of these underlying principles, which in my submission are important when one comes to look at the challenge of the judgment of the Court of Appeal when it came to pleading points. So if we could start, please, at page 1496. At paragraph 29, you see that the submissions are recorded that concurrence déloyale as a faute under the more general tort Article 1382 has been the subject of some jurisprudence, and notably in the context of poaching, passing off, and breach of restrictive covenants. And there's then a citation from the Fernie Spinning Mills case. And you see what's said there as to general jurisprudence about the act fautif. And then moving down to paragraph 30, so that Mauritian decision echoes what's set out in French doctrine on the matter. And there's a quotation from Dalloz. And at 31, a summary of what's to be drawn from that. And then over the page of 1497, a couple more references to Dalloz at 33 and 34. And at 35, you see it was said, this is an important consideration in the present matter under Rule 13.1 of the Supreme Court rules and our jurisprudence. All averments of fact which must be proven for a claim to succeed, which include the actual act fautif, which a plaintiff in a concurrence déloyale action avers, need to be specifically and expressly pleaded. Now, without taking you to the detail of the intervening paragraphs, if I can take you to paragraph 40 at page 1500. That Mr. Bassett and his team were in fact complaining at trial that by now mounting a case based on alleged breach of licence conditions, Emtel was departing from its pleaded case. And so you see that as at paragraph 40, it said that for the very first time, it was stated by Emtel that its case was not one of unfair competition, but one for regulatory breach. And you see a citation there from Mr. Brealey's submissions, raising the question of breach of licence condition. And then 41, similar point. And then 42, there's a complaint that in fact Emtel was at trial seeking significantly to depart from its pleaded case, and they shouldn't be allowed to do so. Now, as we'll see, the judge decided that Emtel was able to advance a case of breach of licence conditions, and we didn't appeal that conclusion by the judge. What these submissions then go on to do at 43 is to consider what this regulatory breach case entails. You see reference to 43, for example, to condition 7B. And then the second half, please, of paragraph 44 on page 1501. You see CELPUS making the point that whilst that's the clause which is averred by Emtel, there's no condition as regards cross-subsidisation in CELPUS's licence. In fact, there's no clause concerning the appointment of an auditor either. Of course, it's open to the authority to impose in a licence conditions which it finds appropriate, but this wasn't the case here. Then, if I can take you down to 47, you see Mr. Bassett and his team make the point that in any event, the distinction which Emtel makes of its claim being for regulatory breach doesn't affect in any way the need for it to prove predatory tariffs as an acte fautif, preventing or restricting competition. And at 48 and 49, over on 1502, that's developed by reference to some French jurisprudence. And so you see at 49, there's a quotation from a French textbook, Aurélien Condamine. I'll give you the reference. I don't think I need to take you to it now, but we have that in the papers at 6081 in translation. But you see the point that was made in Condamine, which CELPUS was relying on, was that in a case where the complaint is one of cross-subsidisation, it's not enough simply to show there's been some cross-subsidisation. It has to be shown, essentially, that the cross-subsidisation permitted and enabled predatory pricing and or une pratique commerciale qui, sans être prédatrice, a entraîné une perturbation durable du marché qui n'aurait pas eu lieu sans elle. Essentially, a significant and lasting disruption to the market.
I hope you can help me. I'm slightly struggling to understand what this line of submission how it interacts with the issues which we're being asked to decide.
Well, my lord, I'm going to come to that in just a second. I'll leave this document in a minute, and then I'll, as it were, place these submissions in the wider picture. But in my submission, they are important for understanding the judgment of the Court of Appeal, particularly when it came to the pleadings. And just to round this off at 52, you see what CELPUS said his case was and remains. And I make the point, my lord, partly because I'm correcting something Mr. Brealey said when he said, oh, it's common ground, the breach of a licence condition would be an acte fautif. That is not and has never been common ground.
No, but it's not a matter we're having to decide, is it?
No, no.
That's one of those reserved matters which, depending on the outcome of this appeal, goes back to the Court of Appeal.
Absolutely, absolutely. My lord, you see the points made at 52. I make it because quite a lot was said, if you like, which I took to be on the merits. The CELPUS position is rather unattractive. And CELPUS accepted that a breach of licence condition would be an acte fautif, then changed its position and so on. It didn't and doesn't. And we submit this is the answer to quite a lot of the complaints made by Mr. Brealey. We don't say, if there was cross-subsidisation, which was another contentious issue, that Emtel would be left without a remedy. But we say its remedy would be to proceed under the jurisprudence, seek to show predatory pricing or a lasting disruption to the market.
But isn't that what the judge found on the facts?
My lord, my lady, she didn't. No. She was seduced by the submission that a mere breach of a licence condition is enough. And Emtel, in fact, expressly eschewed any case based on predatory pricing. Now, the other point I draw from that, of course, is that if one looks for a moment at what Emtel's case, we say, has become, that there was an act fautif during period 1, consisting of operating without a licence, charging a zero tariff, then you would expect that to be pleaded. That's a distinct type of act fautif to the act fautif dealt with in the judgment, namely breach of licence conditions. And I'll come in a moment to the judgment in a little more detail than my learned friend did. But we'll see that the judge very clearly understood the case before her to be based solely on breach of licence conditions. Before I do that, can I just take you to some further documentary references by way of, if you like, opening? Starting with page 1680.
Sorry, just before we leave your last point, that the judge understood the case solely to be based on breach of licence conditions.
Yes.
I'm not sure how you can say that, because I thought we'd been shown passages in the judgment where she looks at the case in respect to period 1, where it was said there isn't a licence, and the complaint was intervention in the market without a licence, and she did award damages in relation to that. She both understood that was the case and awarded damages in relation to it.
Well, my lord, again, I'll come to it.
All right, okay. I don't want to take you out of your course, but
no, I will
help
come
us
to
with that.
Yes.
Okay.
When I say she perceived the case as one of breach of licence conditions, I mean as an act fautif. Specifically, she certainly did take into account period 1 in assessing damages, but in terms of her findings as to an act fautif, that was limited to, and we say very clearly limited to, breach of licence conditions.
I see. Thank you.
But again, just so that I don't have to chop and change to too many documents once I'm in the middle of my submissions, if I can take you to some documents now. Firstly, page 1680. This you'll see is a memo or letter from Mr. Makun Lal, the temporary manager of the authority, to the ministry. And after referring to some preliminaries in terms of preceding communications, it says, I'm directed to inform you that A, the authority has maintained its earlier decision to refrain from granting any exclusive rights to Mauritius Telecom in its licence, and to 2, restrict the number of cellular operators to 2 until the 31st of December 98, and to restrict the provision of the cellular telephone service using the GSM technology to MT until 31st December 98, through an administrative policy decision. Now, of course, at this time, CellPlus hadn't yet been incorporated, so MT was having the dialogue with the TA about the anticipated licence and about questions of exclusivity. But in my submission, this is interesting and relevant because we see here that it looks as though the TA took a considered decision to essentially grant exclusivity to CellPlus, but to refrain from doing so in its licence, and instead to do so through administrative policy decision. This is why I submit, perhaps unsurprisingly, it's clear that the TA was alive to the possibility of having a dialogue with market participants at different levels. Not everything had to be reduced into something in the license. And I'll develop that submission in due course. But I'll come back. That document we submit provides much of the answer to Emtel's reliance on what was said about exclusivity. Because it seems the TA did not, for whatever reason, had decided that exclusivity would not be stipulated for in the license document itself, but rather by way of...
That's one way to read it. Another way to read it is to say there were only two competitors for a license at that stage. One is Emtel, one is Mauritius Telecom, and it's not going to give any exclusive rights to Mauritius Telecom. Mm-hmm. Well, now, in the end, it did give a short exclusive period to a company which, at the time of this letter, hadn't even been formed, namely Cell Plus.
Yeah. Yes, although the second limb of A2, to restrict the provision of GSM technology to MT.
Yes.
Until 31st of December. So that is, in essence, exclusivity.
B is also interesting, that the authority has also agreed, if you go to 3, that MT should operate the cellular service on the same interconnect terms as those offered to Emtel.
Yes.
Well, and 2, isn't the separate accounts? Yeah. I mean, separate accounts is a sort of cipher for no cross-subsidization.
So this is essentially the conditions relied on by Mr. Brearley being decided on by the authority back in 1995.
Yes, although I'm not sure that one can say that merely saying it will maintain separate accounts means that there must be no cross-subsidization.
Oh, really, Mr. Casey?
Well, my lady, yes. I mean, there is a point here, we say, a point of unreality. What was MT to do? Presumably, is it said that it could have capitalised Cell Plus with share capital of 2 billion rupees, and then all would have been fine? But my lord, it is interesting and significant. We say that in a document, in a very document in which the TA is showing that it appreciates the distinction between specifying things in a license and keeping them out of the license.
And this document you're showing us is the authority effectively consulting the minister to see if he's got any objection, looking at the last paragraph, before the license is issued.
Yes. Yeah. Can I go then to the license itself? And at 1715, there's the covering letter from the TA to Cell Plus, enclosing the license. And then, if I can just draw attention to some passages which we rely on. Firstly, at section or article 1 on page 1716. One of my points about the document itself being inconsistent with some part of the license being found elsewhere. Cell Plus is hereby authorised, subject to the conditions general and special hereinafter contained. And then so on. Point number 2, we see that from the date of grant, the license was made retrospective. And although we know this date was later referred to and the authority said that's going to be changed, it was from the very point of grant, retrospective to cover the entirety of what's now called period 1. And then through to page 1718. I'm sorry, I'm asked to take you through also to clause 3, 3C. Which we say is consistent, of course, with section 17 of the Act. And then, if I can take you through to 14 on page 1718. You see it said the general, the special conditions and the 4 schedules annexed to this licence shall be read together and form one document. Now, if that had also said, and paragraph 7 of the press release, then you can see that there would have been a case for saying that the paragraph 7 was intended to be to set out licence conditions, although it would have been unworkable. We say that too is inconsistent with the idea that licence conditions are also to be found floating around in other documents such as press communiques and correspondence, which again I'll come back to, but we submit will create a very undesirable and dangerous state of affairs for licensees. Can I show you also briefly General Condition 9?
Sorry, just before we move away from that,
yes,
are you going to deal with the 3-year licence point, which was in the separate document, page 1731? I mean, did that, the 3-year exclusivity, did that form part of the conditions of the licence or not, do you say?
We say not.
Not, okay. But you'll come to that in due course.
I will do, my lord, yes.
Yes, okay.
I see there's a clause in, a condition, I should say, in the schedule headed up General Conditions. Looking at condition 9
Yes.
on page 1721.
Yes.
The licensee, that's Cellplus, shall not enter into any agreement or arrangement which shall in any way restrict competition in relation to the service, to the operation of the service or any other telecommunication service licensed by the Telecommunication Authority.
Yes. Emtel advanced no case based on that provision of the licence.
I see.
And again, my lord, we submit it's significant that the TA did include in the general conditions this particular provision dealing with competition, but didn't also include some analogue of paragraph 7 of the press release. My lord, that was the only other provision of the licence I was going to take the board to at this point. So if you're happy to move on, could I move to the press release? Which you may have in a couple of places, but I've got it at 1638. And if I can take it straight through to the crucial paragraph, paragraph 7, page 1640. just considering for a moment the suggestion that this language is intended to impose license conditions on Cell Plus. Firstly, 7A, well, that's not within Cell Plus gift. Cell Plus wasn't a party to the interconnection agreement between MT and Emtel. And there was no suggestion that it had seen it. That's really an indication by the TA, and I'll come in a moment to what I mean by that, to MT, as to something that the TA expects to see happen. And then 7B, just taking 7B at the moment of issue of the press release, which is important because we know that the Section 12 machinery is not relied on. So this is said to be the condition imposed on Cell Plus on the 5th of September. The condition is that the authority will appoint an independent auditor to certify that Cell Plus is keeping separate accounts and that is not benefiting from any cross-subsidization. Now, clearly that conveys that the TA desires that separate accounts be kept and desires that there be no cross-subsidization. But as a matter of sheer language, you can't say that 7B is semantically a condition which is being imposed on Cell Plus with which it can comply. The burden of it is that the authority has decided that the authority would appoint an independent auditor to certify certain things.
Well, it's described in the first line of paragraph 7 as a condition.
Absolutely. My Lord, it is.
And doesn't it impose, if it is a condition, doesn't it impose an obligation on Cell Plus because they have to let the auditor into their offices, show them the books and so on?
Well, I'm not sure, my Lord. I'm not sure about that. In any event, we know from the board's decision in 2000 that the TA, in fact, lacked the power to appoint an auditor. No doubt the TA could have said to Cell Plus, we say in its license, it is a condition of your license that you shall not allow yourself to benefit from any cross-subsidization from MT. Or that you shall produce to us with whatever frequency accounts and so on, showing that you're not doing so. But in my submission, simply as a matter of if someone's trying to work out, well, what is the condition that on the 5th of September, assuming it read the press release, Cell Plus is supposed to think it's now subject to and at risk of criminal liability if it doesn't comply with it. It reads it and it says, well, I'm being told that the authority is going to appoint an auditor to do something. This is not the authority saying to me in directive language, like you have with the other conditions in the license, something must be done by you. The authority had power, my Lord, you may remember, from, I think it's section 14 of the Act, to require licensees to produce such reports, accounts, and so on as it wanted. So it didn't need, if I can put it that way, to construct a license condition vis-a-vis Cell Plus to impose such an obligation. Now, we do, of course, accept, though, that this document conveyed to the readers the TA, amongst other things, wished there to be no cross-subsidization. It wasn't a completely empty communication. But we submit this, that it's perfectly possible for a regulator to have a level of dialogue with regulated market participants, in which it says, sub silentio or otherwise, there are some principles and considerations which we wish you to adhere to in conducting your business. And we expect to see from you evidence that you are doing this. If you don't, then we may have to consider using our powers to impose an appropriate license condition on you. It's perfectly possible
it's
for
a sort of precondition, is it?
Well, my lord, I think it's in terms of the levels of dialogue that a regulator can have with licensees. It doesn't have to put everything into a license condition to make it meaningful and important. So we don't say, oh well, paragraph 7 was completely without significance. We say that it only had significance at that level, which, when one comes back to this case, is important because, as my lords and ladies have observed, the board is looking at the relatively narrow question of whether what were relied upon by Emtel as license conditions were license conditions as opposed to something else.
As opposed to a wish list.
Yes, or an expression of policy by the regulator, but not reduced into the clunky machinery of license conditions. And there may well have been some difficulties in trying to draft a license condition as against CellPlus, requiring it not to benefit from any cross-subsidization from its parent. The TA might have thought, well, general condition 9 was enough for that, coupled with this regulatory encouragement.
I mean, general condition 9 is very, well, vague.
It is.
I mean, this is much more specific.
Yes, but the greater must include the lesser, one might think. But the fact is...
But I mean, if you're concerned, you seem to be making a point that, well, these don't have the character of conditions because it doesn't tell CellPlus what it's expected to do. One might think that this is rather more specific at intimating to CellPlus what it's expected to do than Regulation 9, which clearly was a condition.
Well, my lord, in my submission, it would be a pretty odd way to go about telling CellPlus that it must not allow itself to benefit from any cross-subsidization, to say, we are hereby informing you that we will be appointing an independent auditor to certify certain things.
Yes, thank you.
And Emtel didn't seek to suggest that there was a breach of general condition 9. And you might think, well, that's because they might have thought, well, I can't show that what happened over the relevant period prevented competition, and I can't show that it restricted competition. Those are the things, at least on the face of the license, that the TA was concerned to make sure that CellPlus didn't do. My lords and ladies, I see the time.
Is this a convenient moment?
I think it probably is, yes.
Thank you very much, Mr. Casey. We'll adjourn then for the day and resume at 10:30 tomorrow.